on the agenda for today, we'll be going through protecting your intellectual property rights. We'll be going through different types of intellectual property and their legal importance and why it's important to even protect your intellectual property. We'll go through how to do that. And then as usual, we'll go through a Q&A with Damon at the end of the presentation. Just a bit about LawPath. You're probably familiar with what we do. We create smart, simple legal for small businesses through our contract management system, which is end-to-end, backed by nearly 500 templates with e-signature. And it allows you to also connect with lawyers and accountants on demand in a single platform. And we've been in business for over 8 years now, garnering over 10,000 five-star reviews and helping nearly 400,000 Australian businesses save more than $100 million in legal fees. So just getting started on this mission, and without further ado, I will pass it over to Damon to introduce himself and kick off today's presentation as well.
Thanks, Ryan. Hello, everybody. So I've been a lawyer for more than 15 years. I'm the Chief Legal Officer at LawPath. And what we do is when most of our clients have issues, they can book in a legal consultation with us if they've subscribed for the legal advice plan, and the lawyers of our firm can help. Now, today we're talking about intellectual property generally, and I'm just going to share my screen if that feature's being available.
I'll just fix it for you, Damon. Yeah.
Okay, thank you.
It'll be good to go.
All right. Now, feel free to ask questions in the Q&A, and I will answer those at the end. Now, I think everybody can see that. Perfect. Okay, so what is intellectual property? Today, we're talking about intellectual property, how to protect it, what the steps are involved in that, and really just what it is generally and how it applies to each of your businesses. So intellectual property is anything intangible. So it can be the Coca-Cola bottle, to the Coca-Cola logo, to the ingredients in the Coca-Cola. It's effectively anything that's in writing. And so if you look at your business, you have the name of your business. That is a business name, but a business name doesn't necessarily protect your business. So the business, what you do to protect your business is you get a trademark. Now, you might have a website, and your website has a bunch of images that you might have taken. Well, those images are copyright protected as well. And we'll get into the difference between a copyright and a trademark and a patent and a design. But for most of you, you're going to be dealing with copyright and with trademarks. So I'm just going to turn off my Slack. Sorry, just 1 second. I'm not sure if you guys use Slack in your business, but effectively what it does is it enables you to communicate well within your office. All right. So copyright laws in Australia. So let's talk about that. We have something called the Copyright Act, and that defines what is protected by copyright. And effectively, it goes in and talks about anything that's literary, artistic, musical material. So for instance, if you were to look at a song that someone wrote, you might have heard of different cases where people have been sued for taking snippets of another song, maybe from the 60s. That's because that song has been protected by copyright. But it's anything that's written. So copyright is automatic in Australia. So it doesn't matter whether you register it, because in Australia, you can't register it. In America and Canada and different countries around the world, you can register it. But in Australia, it's just automatic. It comes into existence when you brought it into existence. And all you have to do to prove that you own that copyright is by effectively showing that you wrote it or you brought it into existence. So the content of your website, for instance, that will be copyright protected. Now, a trademark is a protection of your business name or your logo, and you register that with IP Australia. So IP Australia is a government organization, and what it does is it protects you from anybody else using the same logo or using the same business name in your industry. So there's around 45 different classes to register a trademark in Australia, and they range from alcoholic beverages to different foods, to merchandise, to business services. And when you register a trademark, you've got to choose your class of what you're going to register your trademark in. So if you're a business advisory business, you're going to register your trademark in a business advisory class. If you are selling alcoholic beverages, as I mentioned, you'll be registering it in the alcoholic beverages class. Now, people can have trademarks in different classes, and people can also have a competitor potentially who has the exact same name as you, but in a different class. And I use the example of a company a long time ago called Barefoot. There's Barefoot alcoholic beverages, and then there's Barefoot footwear. And in that case, one company registered their trademark in the footwear class, the other one registered their trademark in the alcoholic beverage class. They both have the identical name, and that's okay because they're not competing against each other, and they both protected their intellectual property in those two separate classes. But then it becomes an issue of when they both go and want to sell merchandise, and then they go both register a trademark in the merchandise class. That's when it then becomes an issue, because neither of their primary business is in merchandise, and it's just a side business. And then you end up with a legal case, and that's why I've mentioned this one. Now, if you have gone and you're about to start a business, or you have already started a business, the most important thing for you to do is Google. You want to Google whether anyone else has a business that's operating that's similar to your business name or substantially the same to your business name. Also, when you create a business, you don't want it to be generic. You don't want to call your company Number One Taxis, because you're not going to get a trademark in the taxi service class, because what a trademark does is it stops anybody else from using those words together in that specific industry. So if you're doing an online marketplace and you want to call it Number One Online Marketplace, you're never going to get a trademark for that, because it's too generic. It's nothing unique and specifically descriptive of what you're doing, and it stops anybody else from using the words Number One Marketplace. So you want to come up with a name that's going to be more specific and not just generic. And that's how you're going to end up getting a trademark, and that's how you're going to end up being able to protect your business. Now, when you have intellectual property, for employees, if they do any work for your business, it automatically becomes owned by the company. That's because past case law has says an employee has a duty of fidelity, good faith, trust, and confidence, and all these other duties. And any intellectual property they do in pursuing their duties in the company is automatically owned by the company. But for a contractor, it's the exact opposite. If you hire a contractor, anything that they do for your business is automatically owned by the contractor, unless you have a contract that says what they're doing is owned by your business. And we have these scenarios where you kind of touch upon intellectual property, and one's called the moonlighting problem. And that's effectively where you might be currently an employee and you're working in a business, and let's say you're in the construction industry and you realize that there's a lot of defects in the building work, and you say, based on my knowledge in this business right now, I can see that there's a new software that I could create to deal with defective works a lot better. And so I'm going to go and quit my job and create this new software. Now, the issue is that the only reason you've become aware of this problem is because of the information that you got in your role as an employee. And it could be a case where the employer could claim ownership of your invention, because this is a situation where the idea has arose based on your position pursuing your duties, and you would never have known that this was an issue if you didn't have access to your employer's confidential information. So if you are currently working somewhere and you're starting up a new startup, you might want to look at your employment contract and have a look and see whether you have an intellectual property clause that covers inventions. And if that is the case, it might be that you want to get legal advice, because it could be that your past employer then claims ownership of it. We also have the Zuckerberg issue. You probably have watched the movie Social Network that came out a long time ago, but in that case, the Ziggleboff brothers, or whatever their name was, they hired Zuckerberg to go and create Connect You. And in that situation, they didn't have a contract with Mark Zuckerberg. And so what he did was he said, well, I'm going to take ownership of this idea, and I think it's great, and started Facebook. Now, the problem is that anything that he was creating at that time, because he was a contractor, was owned by him. And there was no written agreement as to whether he had a license or whether he was going to transfer ownership or anything. So he claimed ownership of it. And so if you do have any contractors doing any work for your business, it's really important that you make sure you go and get a contractor's agreement in place to make sure you own it. So if you're going to get someone to do graphic design for you and build your website, or make your logo for you, or come up with anything like that, you need to make sure that you have a contract that says that you own it. Now, if you haven't, it's not too late. You can do something called an IP assignment deed, and that looks backwards. And that's situations where you might have hired someone off of Fiverr or one of those online platforms, and you didn't get a contract in place. And you can always go back to them and say, look, I've got to have a contract. Can you just confirm I own my IP and sign this intellectual property assignment deed, where they assign the IP over to you? So just to recap, if you have employees, the IP that they create is automatically owned by you or your business. If you have a contractor, it's not, and you must have a contract. Now, copyright, we've touched upon it: books, drawings, paintings, photographs, music, films, computer programs. One of the biggest things that we do now in the firm is computer software, and protecting the intellectual property in that. And not all intellectual property can be patented, because it has to be innovative. It cannot have been in the public domain previously. So if you have an invention and you have already launched it into business, it could be too late potentially to get a patent. And so you should go and talk to a patent attorney as soon as possible if you're launching your business and you think you might be able to patent your product. And I'll get into patents after this slide. But if we look at copyright, just think about it as anything in writing, whether it's music notes or a book or anything like that. And as I mentioned before, it's automatic. So it automatically is owned by you. If you have an issue and you think that you might not be able to prove that you're the author or you're the owner of it, then what you would normally do is if you drafted it, you might email it from one email to another email, and that timestamps it. Back in the day, I used to recommend people send a post through Australia Post with a print of what they had written, and then not open that envelope, because that proves the date that you had sent it, because Australia Post stamps it. Nowadays, you can probably just send yourself an email. But on that point, I'm doing software enforcement at the moment of breach of copyright, which is essentially someone's downloaded my client's computer software, found an illegal key, and then they've opened up the software. And so our process now is saying, well, back in 1989, we hired an employee under an employment contract, and his name was X, Y, and Z, and this is the company that owned it at the time, and then this company's then sold it to that company, and we actually have to show and prove ownership. So it's good for you to have records of who's making what and have an employment contract in place, so that if anyone questions whether you own your website, you can say, well, yes, I hired this guy as my website developer. Here's the contract. He's the one that developed it, or she's the one that developed it for me. Now, if you are the creator of the copyright, anything in writing, essentially, then you have the exclusive right to it. You have the exclusive right to license it to other people. You have the exclusive right to publicly display it. And I've had some federal court cases where someone has taken a picture off the internet and have put it up on their Facebook page, and then they got a letter from someone in Hawaii who said, that's my picture, I'm now suing you for damages. And the damages are the normal license fee that I know might charge for selling my photograph. And so another thing just to be careful of is, if you're going to get stock photos or anything like that, make sure you're getting it from a proper website, and not just stealing the images off the internet, because there are certain circumstances where the images on the internet have these little cookies embedded into it, and they can see everybody that's downloaded those photos and who are using them. So if you are publishing brochures or anything like that, make sure you get your photographs from a reputable source that has a license that enables you to actually use those images, like iStock or something like that. Now, at the end of the day, it's your responsibility to protect copyright. And it's not that easy, because copyright, to protect it, you have to also be able to enforce it. And to enforce it, you got to sue in the federal court, which oftentimes is a costly exercise. But a couple defenses that are available to people is in the innocent infringer defense. And that occurs where someone might have taken an image off the internet and have used it, but didn't know it was protected by copyright. The argument would have been, well, you should have known, but you can use what's called an innocent infringer defense, which is saying, well, if I didn't know, and I'm sorry, and I'm going to rely upon the innocent infringer because I innocently infringed upon your copyright. Now, they won't have that defense if you have a little c. So if you look at a website, for instance, you'll see in the bottom right-hand corner, it normally says copyright owned by blah, 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 with a little c around it. Or you'll have terms and conditions on your website, which will say all the intellectual property in this website is owned by me. Or you'll have an employment contract or a contractor's agreement or a services agreement or whatever it might be. So if you do have any copyright that you want to protect, you need to make sure that you have a little c on it, because that will make sure that anyone that does steal it doesn't have a defense of the innocent infringer defense. Every country is different in terms of copyright, but in 2005, we entered into the Copyright Amendment Act, and that was because Australia and America did a free trade agreement, and it was so important to America that intellectual property is protected. We were And so, sorry about that. Working from home sometimes has its limitations with problems with the internet. So I'll just pull that back up. Those are also
Damon.
it's criminal to
Damon?
be able to bring those in. Can everybody hear me okay? Maybe
Sound is a bit
going
garbled.
anyways. Um, so trade How's that?
Hey Damon, can you hear me?
Am I back? I can.
Hey Damon, maybe just turn off your video. It's quite garbled, the audio. It's kind of breaking up.
Is that any better?
Yeah, it seems to be better now.
All right. Maybe you share your screen. That might be better.
Sure.
Sorry about that. Working from home sometimes has its limitations, and today's one of those. I don't have direct connect to the net, unfortunately.
Which
So I'm
slide were
just
you
at
on,
the
Damon?
trademark slide.
Trademarks.
Slide trademarks. So we touched upon trademarks previously. So just give you an example. You end up incorporating your company. You call it John's Plumbing, and John's Plumbing is a company. And you get the business name, and now what happens is you think that you're protected, but all that does is protects another company from calling their business John's Plumbing. Someone else can call their business John's Plumbing Services, John's Plumbing Holdings, John's Plumbing Trading, John's Plumbing anything. And so a business name or creating a company with that name gives you really no protection. And if you want to protect your name, you have to get a trademark. Or if you want to protect your logo or slogan or color or scent, you also get a trademark. So an example is the Cadbury Purple has been trademarked. So no one else in the confectionery industry can use that color purple because they have that protected. McDonald's obviously has their slogans, their words, their everything protected. And that's probably one of the strongest trademarks that you would know. And so if you want to protect that, you have to lodge an application with Trademark Australia in this particular class. And there's two different kinds of trademarks, or three different kinds of trademarks. One is just the word itself. Another one's what's called a composite, which is the word and the logo. And the other one is just the logo itself. So you can decide which one's best. LawPath has an ability for you to register a trademark on their website for a fairly low fee if you were to have a look at their website. Next slide, please. So I mentioned before, it has to be unique and distinctive. And then also, it can't be identical to something else. The other thing is once you can do a search on the trademark database. If you just go into Google and you put IP Australia trademark search, they should then come up with a search, and you can then look up whether anyone else has a trademark, and then you can see what class that trademark's in. But it can't be identical to someone else or even deceptively similar. So for instance, if you were to call a business Fiverr, and then drop the E, so that there might be a company called Fiverr, but there might be another one called Fiverr without the ER, just the E, that would be deceptively similar. So just by spelling it slightly different won't get around that identical requirement. Next slide. Now, sometimes you might have a recipe for goods, or you might have something that is a trade secret. And in this case, we give the example of KFC's herbs and spices, or the Coca-Cola recipe. But it might be that you have a trade secret. And a lot of times people will go and they will sign a non-disclosure agreement before disclosing confidential information to people. And when you do that, sometimes people disclose their trade secrets. Now, the problem is that a trade secret isn't necessarily protected. And the reason for that is that it's not protected until it has copyright ownership. So it's well established internationally that an idea you cannot protect. There is no protection over an idea. It's the expression of the idea which is protected. So if you have an idea and tell someone about it, you can't protect it. But if you have an idea and you write it out in paper, explaining it or drawing a picture, that then becomes copyright, and that then is protected. Now, if you are going to sign a non-disclosure or confidentiality agreement with someone, I always say, do not disclose your trade secrets. Always hold back certain information. You don't need to give everything you know to someone under a non-disclosure agreement, because it's very hard to enforce a non-disclosure agreement. And you also have to prove damages, which you normally can't. So if you are going to share your trade secrets with anybody, it should only be under a services agreement. So once they've actually entered into a proper contract with you, not just a non-disclosure agreement. And the final thing is, as I mentioned, a trade secret, it's only really protected if it's turned into copyright, means you've expressed it in writing or similar, or diagrams and so on. Next slide. Next slide. So some of the things that we consider is what you need to do to protect your company generally. If you have an invention, don't put it in the public domain. Don't tell anybody about it. If it's a trade secret, write it down on paper, draw a picture, talk to a patent attorney. Now, in America, lawyers are called attorneys. In Australia, a lawyer is called a lawyer. We as lawyers are not attorneys, and that's even though that's what you might think based on American TV. But in Australia, we have someone called a patent attorney. And a patent attorney is somebody who has a science degree as a bachelor's degree and then has done a master's degree to be
Hello, Damon.
Hey, Ryan, can you hear me?
Hey. Yes, we're good now. You dropped out for a bit.
Yep, sorry about that. All right, so a patent attorney is someone, not a law firm. They're totally different, and they specialize in getting patents for you, which are based on innovations that are a secret, and you don't want anyone to know. And before you tell anyone about it, you go and get a patent drawn up. And then once it's been lodged, then you can tell everybody about it. Other considerations is, are you hiring someone as an employee? Are you hiring them as a contractor? If you're going to discuss anyone in pre-contractual negotiations, get a non-disclosure agreement, confidentiality agreement, hold back your trade secrets. Don't tell them until you have a proper contract in place, like a services agreement. Next slide. So we talked about NDA. If you've ever heard of anyone call it an NDA or confidentiality agreement, it's a non-disclosure agreement. Effectively, what it's saying is, I'm going to disclose information to you, and when I do disclose that information, you're not allowed to disclose it to anyone else. And you're only allowed to use it for the purposes of in which I'm telling you about it. And finally, once our discussion stops, you have to delete that information and not use it ever again. Next slide. Now, we already talked about patents, so I'm going to skip over this, but effectively it's an invention, something new that you're creating, and you're normally it's in the sciences area, but it can apply to anything really. Next slide. We as lawyers, we don't know whether it's patentable, so we can't advise on that. So you'd have to get someone to advise, being a patent attorney, and it has to be innovative. So it can't be something that's already been created before. And it has to be used for industrial applications. So it can't just be an idea that you can't commercialize. It has to be something that is actually usable to increase the efficiency generally of the world. Next slide. IP filing a patent is very similar to a trademark, because IP Australia is the one that monitors and reviews the patents and enforces them as well if there is a breach. But generally, you would be going to the federal court. Next slide. Now, designs is something a little bit more unique. This is like a Lego brick, or a Lego brick, sorry. Other things that you can think of is bottles and shapes of bottles, like the Omo bottle that you would see, the Kit Kat chocolate bar, which is that shape, and other unique designs. So if you think of off-roading vehicles, might have roll bars, or they might have bull bars at the front, or roof racks, things like that. Those are all designs, and those are also able to be protected because they're not innovative in the sense that it's not a patent, it's not a trademark, it's not copyright, so it fits in the category of design. And it's normally a pattern or shape. Next slide. Now, the eligibility is effectively, it's not as long as other protections, but it's basically for 10 years. And so you get the exclusive right to sell that good without anyone else copying your design for those 10 years. Next slide. Now, to enforce a trademark, it's effectively force copyright, trademarks, designs, patents. You normally go to the federal court. It's all federal law. It's the same across the board federally. And so you normally would first identify the person that is infringing it. You would send a letter of demand explaining why you own it, whether you have a registered trademark, or you've the author or owner of the copyright, or you have a patent. You ask them to cease and desist immediately. And you might also ask for their books and records if you believe that what they've been doing is using your intellectual property for their own benefit. And in those circumstances, you can get what's called a count for profit. You can sue them for the profit that they've earned as a result of using your intellectual property. And if they do not comply, then you issue legal proceedings, normally in the Federal Circuit Court, and you sue them for breach of the legislation, which is the Copyright Act, for instance, or the Trademark Act, misleading, deceptive conduct, because they're holding themselves out as the owner when they're not, and account for profits, which is a suit for the damages. Next slide. And I'll pass it back.
Perfect. Thank you very much, Damon. And again, apologies for the breakup of the audio and video today. We will have a recording available on our YouTube channel. So we've had a few questions on that. How LawPath can help, we do have a full contract management system, as mentioned, of around 460 documents. It does include a number of intellectual property documents, such as a deed of assignment of intellectual property. And on top of that, we do have some personalized workflows. There's about 9 of them now on getting things like permits set up for your business, as well as online legal documents. So these are completely free and you can check them out. Lastly, you can book in legal consultations. So if you have an intellectual property matter that needs handling, you want to discuss, I can see a few questions on specific matters that are quite niche, you can book in a consultation with some of our lawyers on the legal advice plan, and get that on-demand advice, as well as a 4-page document review per session, such as the deed of assignment of intellectual property. We also do have accountants who can provide accounting support if that's what's required for your business. So some of the plans that we do have, we've got the Essentials plan on the left here. This one does provide access to basically 450 documents at the moment, and you've got the full e-signature, you've got the full contract management there, so end-to-end. You can also add in 3 team members if you need to add in, say, different people in the organization who might be doing some work and doing your documents for you. In the middle, we have the legal advice plan. So this does provide unlimited 30-minute calls with our lawyers every single month, again, on new business and commercial topics. There's the 4-page contract review each session, which is fantastic. And then lastly, the legal and accounting advice. We do provide chartered accounting advice with our partners at Pop Business. So we've got an accountant we work with. And if you have any questions on group structuring or asset protection, payroll processing, or even your accounting software, the accountants can walk you through it on a video call. So it's a phenomenal service and great value with the lawyers and the accountants talking to each other about your business. So today's exclusive webinar offer, we are offering 25% off our legal advice plan. So this one does provide unlimited calls, as mentioned, 30-minute calls, phone calls, video calls. There's also live chat with a lawyer. There's a 4-page verbal contract review over the phone, and you do have discounted fixed price quotes on contract drafting. So if you do need something a bit more bespoke written up for you, or something that falls outside of a business and commercial sphere, then you can put in a quote and get a discount. So if you are interested, please key in yes into the chat. We will give you a call. We'll onboard you this afternoon and get you booked in to speak with a lawyer as early as tomorrow or Friday.